I'm going to be doing a presentation for the Desert Bar Associations, their miners council today, on coercive control allegations. My name is Dr. Kim Shirin. I'm a child custody evaluator. I am licensed in California. I specialize in 730, 3111, and 3118 child custody evaluations. I currently perform child custody evaluations from Fresno County all the way down to San Diego County. I also perform 733 evaluations, and for those that are not familiar with what a 733 evaluation is, that's an evaluation of the 730, the 3111, or the 3118 child custody evaluation to make sure that it was done properly and within the standards of the community. The purpose of the presentation comes out of the hundreds of 730 evaluations that I have performed, and I have in consult with some colleagues of mine of Dr. Phil Stahl and Dr. Peter Jaffe. So we're going to go over and look at what the learning objectives are, hopefully by the end of this presentation, and I'm going to try to make it as entertaining as possible, because I don't know if you're like me, I've attended lots of little webinars and stuff, and they get to be real boring, and this is not like a real exciting topic for most people, but I'm going to try to make it as entertaining as possible. I hope you will forgive me for in this, because I normally do these live and not recording one of these. So this is my first time recording it, and hopefully I don't trip over my eye teeth and make a fool of myself in some way. So let's look at some of the ideas of what we can come up with. Hopefully you'll be able to describe the contents of California's coercive control statute and the applications in case law, and the integration of the AFCC guidelines in cases with allegations of interpersonal violence, actually intimate partner violence, and parenting plan evaluations. So what is coercive control? Now, Evan Stark is an English psychologist who has done a lot of work in coercive control. He defines coercive control as the person who is abusive deploys a broad range of non-consensual, non-reciprocal tactics over the extended period, subjugating or dominating a partner, rather than merely to hurt them physically. Compliance is achieved by making victims afraid, denying them basic rights, resources, and liberties without which they are unable to effectively refuse, resist, or escape the demands that offend their self-interest. Now, as we continue to go in there, another definition of that is a pattern of abuse over time. The key part there is being over time, that maintains the power of one intimate partner over another through a variety of means, such as threats, intimidation, and emotional, sexual, or even financial abuse. Patterns of coercive control may be more difficult to recognize than physical abuse, which is more readily understood and identified. The identities of individuals in families influence the ways in which coercive control may be exerted and the opportunity for victims to seek and receive help. Coercive control can have a profound effect on both adult victims and children exposed to this behavior. Now, we come up with Family Code 6320, which was amended. And before we got to the part of being amended, even though that it doesn't mention coercive control, it is filled with parts of coercive control. So let's take a look at Family Code 6320. The court may issue an ex parte order enjoining a party from molesting, attacking, striking, stalking, threatening, sexually assaulting, battering, credibly impersonating, as described in section 528.5 in the Penal Code, falsely impersonating, as described in section 529 of the Penal Code, harassing, telephoning, including but not limited to making annoying telephone calls, as described in section 6.53M of the Penal Code, destroying a person's personal property, contacting either directly or indirectly by mail or otherwise, coming within a specified distance of, or disturbing the peace of the other party, and in the discretion of the court on showing of good cause in the name of the family or household members. So as we start looking at that, then in 2020, the law was amended to add subdivision C, which includes the definition of disturbing the peace and the definition of coercive control, along with some examples of what coercive control is. The definition of coercive control in 6320 now is coercive control is a pattern of behavior. The optimal part in this is a pattern of behavior, not a single incident, but a pattern. In purpose of effect, unreasonably interferes with a person's free will and personal liberty. Examples of coercive control include, but are not limited to, unreasonable engaging in any of the following: isolating the other party from friends, relatives, or other sources of support, depriving the other part of basic necessities, controlling, regulating, or monitoring the other party's movement, communications, daily behavior, finances, economic resources, or access to services, compelling the other party by threats of force, intimidation, including threats based on actual, suspected immigration status, to engage in conduct from which the other party has a right to abstain, or to abstain from conduct in which the other party has the right to engage. So now all of a sudden it's now including even the concept of immigration. So now when we get to 2009, we start to see some of what is starting to happen here. The law is starting to associate things with different things, and so now what we're looking at is the marriage of Nat Carney in 2009. The Domestic Violence Protection Act, the DVPA, was intended to provide protective orders to a broader class of victims of domestic violence. It's a federal law. The DVPA reflects the legislature's goal of reducing domestic violence and in the recognition that it is virtually impossible for a statute to anticipate every circumstance or need of the person who it may be intended to protect. Courts must be entrusted with the authority to issue necessary orders suited to individual circumstances. Nat Carney was the first appellate case to define disturbing the peace. So as we keep looking forward here, we start to see how domestic violence and coercive control are starting to become more and more important in California law. In 2014, AB 2089 recognized the concept of coercive control. Domestic violence is not limited to actual and threatened physical acts of violence, but also includes sexual abuse, stalking, psychological and emotional abuse, financial control, property control, and other behaviors by the abuser that are designed to exert coercive control and power over the victim. how does coercive control look in the appellate decisions? Let's first look at the disclosure of information. And I'm sorry if I mispronounce the names here. Eviser versus Sweeney in 2015 disclosed and threatened to disclose intimate details of his ex-partner's life. Now, in that, we're not talking just about, a few slides or something along those lines. What we're talking about here is a lot. There's hundreds, if not thousands, of emails and social media posts that we're talking about in this. So as we're looking at that, that is where they started to see that that was now part of coercive control. And then we start looking at the distribution of information, which then became also part of coercive control, even though, coercive control had not really been defined that well in the California legislature. The appellate court is ruling that the distributed details about a partner's affair to co-workers, relatives, and friends, and Altafua, I may be pronouncing that wrong, versus Irwin, is Irwin was taking this and threatening to be able to do that with, and that is where the appellate court came down and said that was coercive control. Monitoring behaviors in Rodriguez versus Minajara in Vara in 2015 caused the partner to keep a phone line open when at home or at school to check on it, constantly trying to check on it. And that was what the whole part of that was all about. And so that also came under the ruling of coercive control. The social media and distributions, also Phillips versus Campbell in 2016, harassing messages, posts of information and photos on Facebook, videos on YouTube, and sending messages to others, including calling partner psycho evil witch and a compulsive liar. That was ruled. So now then, coercive control in co-parenting in Romo versus Riley, I may be mispronouncing that too, as I apologize, threatening to show up at school events, sporting games, standing closer than the restraining order would allow, and other such activities using the child's events as a mechanism to disturb the ex-partner's peace. That was the concern about that, how that was going. And so then we went to McCord versus Smith in 2020. Perhaps one of the most single acts might have not led to RFO, but the court needs to see whether the totality of the circumstances support an issuance of a restraining order. And so it's not just an individual act that they were looking at, it is the pattern of events. So now we start to think about, why is family violence and coercive control relevant in parenting disputes? Abuse does not end with separation. Now, if most of us who have some time being in this field realize that after separation, it seems to escalate sometimes even more than before. There's an undermining of the non-abusive parent, the perpetual litigation as a form of an ongoing control, where one parent is taking the other one into court all of the time, overlapping between child abuse and domestic violence. Children exposed to an inappropriate role model. New relationships potentially violent. When one of the parties gets a new relationship, that sometimes reignites the entire fight. Or in extreme cases where we have homicides and abductions. Those are more rare than the others. So how do we assess this coercive control? So as we start looking at that, we start looking at the wheel of power and control, and looking at how all of these parts start to fit together. The using of isolation, the using of emotional abuse, using intimidation, coercion and threats, economic abuse. I remember years ago I had probably one of the first cases that I did an evaluation on, where the parent was considered domestic violence and had a restraining order placed on him due to economic abuse. Using the children as a tool, minimizing, denying, blaming, all of these things are part of that power and control. So as we look at what's the impact of coercive control on adult victims? Well, your client may feel afraid for themselves or loved ones, unsafe due to the violations of no contact orders, worn down and exhausted, as being in the court system can do, and being constantly involved in a fight. That fight or flight instinct that occurs is that when you're in a constant battle, you can be worn out and exhausted. And what happens at that point is then they start second guessing themselves at the whim of their ex-partner, always feeling that they're at their whim, financially dependent upon their ex-partner, unable to get away from their ex-partner, micromanaged by their ex-partner. Their daily activities are disrupted by calls or whatever. Feel like they're going crazy. They cannot trust their own decisions. Now, any of the impact of the above may be signs of coercive control and family violence. It is important that your clients can share their experiences in court and receive counseling they require from specialized services in the community. Their children may require counseling to deal with the family violence that they've been exposed to. Now, one part of this what we really need to look at is when I say specialized services, the counseling needs to be specialized, trained counseling services, not the run-of-the-mill counseling service, but somebody who is specialized in this. The perpetrators of coercive control need to acknowledge and take responsibility for their behavior as the first step in getting help for themselves. Most perpetrators are not usually willing to do that, but that's part of what we need to be able to get them to do to start the process of healing. Lawyers should look for patterns of behavior. Know that violence is likely going to continue following separation, and understand how to deal with the impact the family law process and parenting arrangements are going to have. The impact of coercive control on the victim's parenting. Well, it's traumatic. It's a trauma. The impact may be short or long term. The impact may occur pre or post separation. Feeling demeaned, belittled, and are undermined as a parent. I just got through with a case in where one of the parents is convinced and actually almost convinced the other parent, which in this case was the mom, that she was crazy. And that I had to do a psychological evaluation to prove that she was not crazy, so that we could rule out getting an RFO on her. So credibility and authority of a parent is compromised by abuse, disruption, litigation, and poverty. It can be situational or an enduring problem. May engage in protective behaviors, which is normal for people who are feeling that they're under attack. Now, what is the impact of coercive control on children? So, protecting children living with domestic violence. The parental separation is often essential for the long-term protection of victims and children from serious family violence, especially coercive control. But separation can increase the immediate risk of serious harm or death from family violence for adult victims and children. Intervening in family violence cases requires a recognition of the harm to children in these circumstances. 10 to 20% of domestic homicides victims are children. That's a big number. Children who survive the exposure of horrific traumatic events from one or both parents' lives are disrupted forever. Children often used as a tactic to harm the mothers, sometimes the fathers, but a lot of times it's the mother. So most of the time we'll talk about it being the mother, but to realize that sometimes there is a father issue in there too, is where mom is just as good. It's not that guys are that great. Women can also be good at being coercive, controlling too. So keeping her in the life of an abused parent, harassing her, stalking her, keeping track of her, having to make sure that she knows where she is at all times, intimidation, threats to harm the children, destroying the mother-child relationship, withholding financial support, interfering with routine parenting practices. The misuse of the friendly parent. This is something we can all end up falling prey to. Raising concerns about the family violence can be misused against the victim parent as an evidence of poor parenting capacity or unwillingness to engage in the friendly parent. Significant caution should be used in making negative interferences about a parent as a result of allegations of family violence by the other parent. Communicating fear for the children as a result of family violence, or taking measures to protect the children or getting help for family violence. Litigation abuse. I think this is a biggie. Family violence may well increase a victim's financial and emotional cost in the court's process, but may be essential to protect their children. Lawyers, judges, family justice professionals need to be aware that abusers may misuse the court process to continue patterns of coercive control in their intimate relationship in court proceedings. In some cases, this behavior may be tantamount to litigation abuse and an attempt to exhaust the victim financially and emotionally. Litigation abuse. The court process may need to have orders that protect the victims and the children. The adversarial process and due process may help court discover the truth, but the adversarial process may also be manipulated and exacerbate the conflict. Litigation process abuse includes prolonging the process, abusive communications, failure to properly disclose information, rejection of reasonable settlement offers, dishonesty in documents and testimony, the violation of court orders. Differentiated responses. Consider for the decision making about post-separation parenting where there are findings of family violence. The parenting of an abusive parent needs to be addressed. There may be an ongoing impact of the parent who has perpetrated family violence on the victim and children, even after separation, and a cessation of any acts of abuse. Findings of family violence are critical to understand the parenting decisions of the victim parent. Family violence can impact the parenting confidence and autonomy of the victim parent for many years after separation. Their self-esteem can be just really, really low and need to have a lot of help. Findings of family violence are usually contradictions of co-parenting arrangements after separation. Co-parenting cannot take place in the context of continuing fear and trauma from a history of family violence. Supervised exchanges or supervised parenting time may be essential for adult and child victim safety. Such safety measures should continue when there is an ongoing risk of family violence and coercive control. Ending these arrangements should be conditional on ending patterns of abuse and controls toward the targeted parent. Now, when we're trying to gather information, there needs to be some ways to think about gathering some information in this. So let's look a little bit at how we could start doing it. Is there a history of the relationship and forms of abuse and threats that have been used to try to control the victim and or the children? So reports and observations of this conduct by third parties, such as friends, relatives, co-workers, or professions are very important. The use of litigation abuse as a continuing form of coercive control after the end of cohabitation. Past and ongoing impact of abusive behavior on the children, on parenting, on parent-child relationships. How to deal with it. Document to demonstrate patterns of conduct rather than isolated acts of abuse. I'm sure all of us have where one of the parents will call us about some isolated act of abuse or trauma that they think is going on, and we may think that it looks coercive control from that one event, but it's not a pattern. We need to look to see that there's a pattern. It could be something else. It could be very harmful to have that, but we need to look for what the pattern is. Recognizing the exposure to a coercive control is harmful to children because it clearly is not giving them a good role model to look at. Document the harm to victim and or children in terms of how the coercive control affects family members. I have a case that I'm dealing with now and where the mother is using coercive control to try to control the father and the child. The court has given the child physical custody of the child to the father. They still have joint legal control, but the mother continues she's stalking the dad and the child. She shows up at places where she's not supposed to, even though there's a restraining order, violating the confines of that, getting closer and invading space. She makes up information to tell the professionals, and she's constantly using the litigation abuse as a way of trying to get to him and get back at the child. So also then we start looking at the impact of parenting arrangements. Co-parenting and joint decision-making are contraindicated since it may allow continuation of the patterns of abuse. Sometimes you have to think about is that maybe the joint decision-making is not the best way of trying to do it. Maybe you have to allow the victim parent to be able, or targeted parent, to be able to make the decisions, or at least have the deciding vote to do that decision. Supervised parenting time or suspension of parental contact may even be required in a case. Then a minimum requirement is highly structured parenting arrangement with little to no flexibility to avoid ongoing disagreements and litigation. I thought now would be a good time to talk about a case example here. I had a case in where the mother had gone on vacation with her girlfriends, and during the time that she had gone on vacation with her girlfriends, Dad had security cameras installed in the house. Now, having security cameras in the house seems like a normal thing to be doing. However, 2 of the security cameras were installed in air conditioning vents so that they were hidden. They were in the bedroom, pointed towards the bed. Now, Dad had done this because he had found a spot on the sheets, and he used that as evidence to believe that it was okay to put the cameras in there without the mom knowing. And he harassed the mother about this issue of having this spot on the sheets and thinking that that was why she was having an affair. Later on, it was discovered that there were the cameras hidden in the bedroom air conditioning vents. And Dad, of course, used the excuse that he had done this because she was having an affair. Now, is this coercive control? And I think most of us know that when we have cases that are in the high conflict variety, is that they may be only a small percentage of the cases that we have, but they eat up majority of the resources that are out there. Now, when we look at parenting disputes with family violence issues, then we need ways to get out of the regular family court process. How can we help these families get out of that so maybe there can be some help and move past this? As far as the family violence, we need, if it's just family violence, not that we just need, is we need protective orders, restraining orders may need to be put in place, risk assessments and safety planning, batterers intervention programs, victim services and counseling. We need specialized parenting evaluators. Just as there are counselors who do generalized counseling, they're not going to be effective in these kinds of cases. And there are evaluators that are good at just the run-of-the-mill cases. But when you have cases that you're involving these high conflict cases and to have family violence in it, that you really need somebody who is highly trained. Most people are, but you need somebody who's really going to be specialized. You need to have some case management going on. One of the tools that I use in my practice is our family wizard that allows me to have the ability that I can monitor in real time information what is going on in the family. I have the ability to go into, as a professional, go into the program, and with the parents' permissions, I can monitor all of their communications. So I can see kind of how things are going and whether or not something needs to be done at that point. Sometimes we have to have supervised parenting programs. There are some very good professional supervisors out there that really know what they're doing and can help in these kinds of situations. Now, if you have a high conflict case and there's no violence, the parenting evaluation and the parent maybe even you have to have a parenting coordination or coordinator involved. Therapeutic programs to reduce conflicts, judicial case management, arbitration, helping them understand how to at least parallel parenting if they can't co-parent. And under normal conflict, what we're going to try to do is help education, provide some mediation services, look at collaborative law, and co-parenting plans. So as we start looking at this, I try identifying family violence and coercive control is only step one in a long journey. We need to be screening the family violence for family violence and abuse, assessing the full nature and context of the violence, focusing on the effects of family violence, and responding to family violence in all recommendations, decisions, and interventions. The implications for coercive control and parenting plans accounts for abuse in actions and decisions. Maybe we need to have is a limited or monitored access by abusive parents. Maybe limited or monitored decision-making authority by the abusive parent. Limited could be is you give one parent having the final vote in what decisions are. Or maybe you make full legal custody go to the abused parent. Monitoring abusive parents' compliance. In other words, that's where we need to have an ability to look at that. That's where I find where being able to see their communications on a regular basis helps to be able to do that. Support the victim parent's effort to protect the child. Strengthening the child's support system. When we start thinking about the abuser, we need to be thinking about, has the abuser been able to change? 4 questions to sort of consider when looking at, has the abuser changed? Has the abuse partner stopped behaving abusively, including stopped using coercive control tactics? Does the abusive partner continue to blame and disparage the victim? Or do they recognize their abusive behavior as unacceptable? Can abusive partners articulate the impact of domestic violence on a victim and the children? Has the parent changed as a result? Are they working to make amends? How has the abusive parent demonstrated that they are safe and supported? What changes have they made? Well, now that we've looked at some of the questions to ask, let's start looking at how we can analyze what we have. So start with looking for multiple hypotheses. Continue to look for multiple hypotheses. Make sure you're looking at the limitations you have in gathering data that might be helpful to formulate a hypothesis. If you believe that the data significantly supports one or more hypotheses over the others, be clear about it. If you believe some data supports one hypothesis, but other data might reject certain hypotheses, then be clear about that as well. With all that in mind, it's good to think about how it can work. So let's look at, it's less likely coercive control if the partner doesn't feel intimidated, doesn't feel fearful, or doesn't feel like they're threatened. The disagreement is an extension of the typical couple's arguments with no negative consequences. There's no typical coercive behavior. There's no threats. There's no isolation, stalking, etc. If the outcome is a disagreement, rather than one spouse having control over the other, then it's not coercive control. Refer back to the definitions in case law, the statutes, the AFCC guidelines. If there's no such problematic consequences and actions, it's more than likely not coercive control. So on the other hand, it may more likely be coercive control if the screening tool, an in-depth interview of both parents and children, reveal the partners and or children are afraid and cannot describe specific experiences. The partner and or children have been threatened, and they can tell you about those threats. The partner has experienced patterns of threats, isolation, stalking, gaslighting, and emotional abuse, and or disturbing the peace, especially if those patterns have increased since separation. And we all know that most of the time they increase after separation. Once again, refer back to case law and statutes and guidelines when explaining why you believe coercive control exists. Some final takeaways. Continue to explore multiple hypotheses throughout your interactions. You do not have to have all the answers, but you need to be thorough in your assessment of what is going on. Stay curious. Make frequent use of help me understand. I want to see it through your eyes. Can you explain it more to me? So that what you're doing is you're constantly being curious, trying to understand, see things. Because sometimes the more you ask questions, the more information you get. Remember that the lack of evidence doesn't mean there's a lack of IPV or coercive control. Even if you only have a he said, she said situation, that doesn't mean that the coercive control is not real. The court is looking for you to be fair, neutral, thorough, and impartial, and looking for the best interest of the children. Finally, when formulating conclusions and making recommendations, be compassionate and avoid labeling people and being judgmental. It's perfectly okay to label behaviors, but not people. We can talk about the behaviors and how that relates to the children and how it's not working well that way. But we need to not necessarily label the people. The author, being unknown, once stated that once we categorize parents, we marginalize not only them, but their challenges. Once we marginalize, we become intolerant. Once we become intolerant, we become ineffective. Be guided by your desire to lower the family tension. Call out destructive behaviors and guide the family on a path of healing and greater peace. Thanks for listening. Thanks for putting up for all of my mispronunciations, stumbling over my eye teeth and making some errors. And I hope I didn't humiliate myself too much in that. But anyway, once again, if you have any questions whatsoever after all this training, please feel free to email me. If it's urgent, let me know why. If it's case specific, I would have a tough time being able to offer case specific advice. Hypotheticals, yes. Conceptual issues, that's fine. And once again, thank you very much for giving me the opportunity to be able to share with you. Thank you very much and have a great evening.